Great. So I'm excited to see everyone joining for our webinar today with representatives of COPAA, the Council of Parent Attorneys and Advocates. I'm Jennifer from Dysgraphia Life, and we're really excited to host this today because we get a lot of questions on how to advocate for your student who has difficulties writing or who has been diagnosed with dysgraphia, and how do you really make sure that you can get services in school-based settings. So we are thrilled to have Jennifer Laviano and Julie Swanson join us today. They are experts in this field and are going to speak to us about special education rights. They have a book, which we'll put the link in the chat shortly. They have a podcast called The Special Ed File and a website called yourspecialeducationrights.com. And so they're here to teach us today so that we can all learn how to better advocate for students with specific learning disabilities and written expression. So Jennifer and Julie, thank you so much for joining us. One housekeeping announcement, we are going to have lots of time for questions and answers at the end. We would like you to put all of those questions and answers in the Q&A box that you see on the Zoom, and then we will ask questions to Julie and Jennifer once they get through the slide presentation.
And thanks for having us. And just for clarification, I'm Julie.
Hi, and I'm Jen. Thank you for having us here today.
Great. So I will let you guys kick it off, and you can just let me know when to change the slides.
Sounds great.
Okay. Well, that's our title slide, so let's move along.
Maybe. There we go.
Okay. So Julie, you want to start here, and I'll get into the IDA when we get to that. We're going to try to go through this fairly quickly so that we have a lot of time for your questions.
Right. Obviously, we're all here to discuss dysgraphia, which is a problem with written expression. And not that I like to read slides, but the signs and symptoms of dysgraphia are when a child can have symptoms such as messy handwriting, inconsistency in letter spacing and capitalization, discomfort or pain when writing, fine motor skill challenges, trouble with spelling, trouble composing written work. And so that is obviously why we're here today to discuss dysgraphia, and we can move on to discussing the actual laws that can help you advocate around dysgraphia. And I think we just put up an evaluation slide just to let you know that obviously a big part of advocating for dysgraphia is eligibility. And in order to be eligible, a child must be evaluated. And on the Dysgraphia Life page, there are a very comprehensive list of evaluations you could be requesting from your school district. Next slide, please. Thank you. Here you go, Jen.
Okay, so methodology disputes. One of the things that we certainly experience in our practices, and we know that many families encounter, is once you have the right evaluation and the proper diagnosis, then the next question is, what is the right intervention? And we know that Orton-Gillingham is an approach that is frequently recommended as the appropriate methodology to use to intervene in this area. The difficulty is this. What we call methodology disputes exist not just in the area of dysgraphia, but in dyslexia and various other kinds of disability intervention. The IDEA, which I'm going to get to in a minute, is the federal special education law. That statute has a structure, and largely a lot of deference is given to both states and local school districts, even though they are required to follow the federal law. And when it comes to choosing which method of educational intervention a child requires, generally speaking, school districts are entitled to pick the method. Of course, it still has to be appropriate, and it has to be appropriate to meet the unique needs of the individual child whose IEP, individualized education program, is the focus of. And so what you need to understand is that the key here is to make sure that you can demonstrate that what your child requires, or the student you're working with requires, is this particular intervention in order for the IEP to be appropriate. It is not usually a good winning strategy for families to get fixated on, I want this particular method in the IEP. because generally speaking, school districts will say, well, that is something that we get to select. Yes, they do, as long as it's appropriate. They're not allowed to select an intervention that has no efficacy for this particular child. And so we suggest to families that they focus on the appropriateness of this approach for their child. And if possible, hopefully you have an evaluation that substantiates the need for this intervention. We frequently will hear, well, we don't put the methodology into the IEP. There's nothing in the statute that prohibits them from doing so, though. And in fact, if you feel strongly that your child requires a particular approach, a multisensory approach, then you should, at least in the paperwork, ask them to document that that's the type of approach your child requires.
Right. And, you know, we might have gotten ahead of ourselves a little bit here with talking about evaluations and methodology, but hopefully once we get into the we're mentioning this because we know that specific to dysgraphia, there are some specific assessments and specific methodologies. But hopefully, once we get into our discussion about advocacy, we'll help you understand how to advocate for all of that. So here's what you need to know.
Okay, so I'm going to give an overview of the IDEA. The IDEA is the Individuals with Disabilities Education Act, okay? It's the federal law that says that when a child's determined eligible for individualized education program, they are entitled to receive a free and appropriate public education, okay? That federal law applies everywhere in the country, in all U.S. territories. You know, I've sadly gone to conferences where I presented and people have said, well, I've been told that actually in my state, this doesn't apply. Yes, it does. Every state receives federal funding. It is federally required in every public school in the country, including charter and magnet schools, most charter schools, but certainly all magnet schools, which are public schools. So the districts have to follow the federal mandate. The easier way to look at the statute is it has two concurrent obligations. They operate at the same time on all school districts. One are the procedures. The procedures are things like they have to give you written notice if they're going to hold an IEP meeting and let you know who's going to be attending. They have to convene that IEP meeting at least annually. They are required to have a regular and special education teacher at the meeting if the student's going to participate at all in the regular education environment. Those are the procedures. Those are the rules. What Julie and I like to refer to in our book is a quote from Jerry Seinfeld, the top of the box if you're playing a board game. The procedures are the top of the box. So the rules of how school districts are supposed to go about discharging their obligations under the statute. But in addition to those procedures, substantively, the school district must offer all children who are identified as eligible a free and appropriate public education. It's referred to as FAPE. There's a lot of alphabet soup in special education. We try to break it down as frequently as you can because it's confusing enough. But the real question when you look at the free and appropriate public education is that A in FAPE, appropriate, because we know free means at no expense to parents. Appropriate, and I'm going to get to in a second, public means publicly funded. It does not necessarily mean in the public school. And education, we just say repeatedly, Julie and I, education is more than just academics. So what is appropriate? Well, that's a question that's been bandied about in the courts for a long time and in our various federal circuits. The most recent guidance we have from the Supreme Court is from 2017 in a case called Andrew F., which is a good read, and it was a decision in favor of the family. That's set some important standards so that it's clear that complying with the IDEA does not just mean allowing a child access to education. It means outcomes. It means goals and objectives that are ambitious. It means that we want children to have a meaningful education. And so that's the standard. And you know, it's not acceptable under the federal law that a child just pass from year to year and from grade to grade without making meaningful progress. Next slide. Okay, so child find. This is a very important affirmative obligation that all school districts have. And an affirmative obligation, what that means in English is that it's not up to a parent or a child to ask the school district to figure out whether or not they have a disability. It's actually the clear obligation of the school district to identify children and evaluate them if they have a disability. And there are a number of red flags that we talk about in terms of reasons that many students with learning disabilities will become school avoidant because of the fact that they're struggling in school and they're not receiving the intervention that they need. So things like going to the nurse a lot, avoiding school, obviously sometimes in extreme circumstances, hospitalizations, disciplinary referrals. There's all sorts of things that can result from a child not receiving an appropriate program in the school district. And these are red flags that the school district should be referring the child for a comprehensive evaluation in all suspected areas of disability. Just for a moment, I want to focus on that all suspected areas of disability. Written expression, we're going to get to in a moment, is specifically enumerated in the statute as one of the factors that can be considered in whether or not a child has a learning disability under the law. But it's very frequent that school districts will do a standard battery of tests and miss the suspected area of disability. So, you might get testing that looks at an IQ score and looks at reading, but doesn't actually address that written expression. So if your concern is written expression, you want to make sure that that's what's being evaluated in addition to the other things that the IEP team may think they want to find out.
And if I could just add something,
Sure.
Another red flag is, that whether or not your child has been referred to RTI, response to intervention, which is a regular education initiative whereby there's a three-tiered system to apply interventions to see if it's going to be effective in helping the child with whatever their deficits are. And so I see a lot of times with kids who have learning disabilities, they might be referred to RTI, response to intervention. And what we want you to know about response to intervention is that it should not stop the process of a referral to special education, and you must not exhaust all three tiers before being referred to special education.
Yes, for sure. Okay, next flag. Yep. The IEP referral plot process, anybody can refer a child for an evaluation under IDEA or 504. I'll talk about 504 in a second. And you need to make sure that you are careful both in that initial evaluation, but also in the reevaluation that the child's being assessed in all areas of all suspected areas of disability. Frequently, once a child's determined eligible for an IEP, when you come up upon that, what we call the triennial, which is that portion of the procedures that says at least every 3 years the child is required to be reevaluated to determine eligibility. Very frequently, school districts will do a much lesser assessment at that point and just say things like, "Oh, well, we already know he's eligible," or things like that. You still want to make sure you're holding your IEP team accountable for thorough evaluation, because it's not just to question whether or not the child's still eligible; it's to determine progress and see from baseline whether there is any progress that we can document, as well as it should drive programming.
Right.
Section 504, just very briefly, is a different federal law from the IDEA. 504 is a statute, it's Section 504 of the Rehabilitation Act of 1973. That rolls right off your tongue, right? That statute is fundamentally an anti-discrimination and accommodation statute. So what it says is that any entity which receives federal funds, which all school districts are, cannot discriminate against somebody on the basis of disability by denying them access to services or supports that their non-disabled peers can access. There's also anti-retaliation provisions, but we don't need to talk about that. That statute is sometimes implicated where school districts don't feel that the child's disability rises to the level that they require specialized instruction, but only accommodations. I can envision a school district, even with a dysgraphia diagnosis, because a diagnosis does not necessarily require an IEP or even a 504 plan. But I can envision a situation, I wouldn't think it's a great idea, but I can envision situations where school districts would say, yes, you have a dysgraphia diagnosis, but we don't think you need specialized instruction. All you need is maybe an extra few days to turn in written assignments, things of that nature. I think most competent professionals would advise that a child who has dysgraphia should be getting specialized instruction on this written expression, but it does happen for all types of disabilities that school districts will say, we don't think it rises to the level of an IEP, a 504 plan is sufficient. And then you have a right to disagree with that as a parent and exercise your due process rights. Next slide. Julie, you want to cover the RTI since I think you already covered some of it, but.
I really did. I think we've said enough about this, and it is a regular education initiative that was originally intended to address identification of students with specific learning disabilities only, and it's morphed into a pre-referral process for many more types of disabilities. And it is fraught with all sorts of comments about how sometimes it's not used in the way that it was designed. And it can be used as a method to many times, whether it's wittingly or unwittingly, used to put off a referral to special education process. And many months, crucial months, can be lost when a child is in response to intervention for too long. But if you've been told your child is in response to intervention, don't just take that lightly. Ask for all the paperwork. Find out, what are the goals that you're addressing? How are you monitoring it? Make sure that once the time period is up, how long will my child be in response to intervention? And get very involved in that process. And it should probably be a trigger. I shouldn't say this as a blanket statement, but by the time teachers have referred your child to response to intervention, there are concerns there. And so they want to test out whether applied interventions are going to help that child. But oftentimes it can be used to delay the process. And it's just fraught with all sorts of controversy. Jen, what do you also have to say about it?
Yeah, and this, which is that frequently, and not just in RTI, SRBI, which is the language from the statute, not just in this area, and SRBI is scientifically research-based intervention or instruction. And so, frequently public education is fraught not just with alphabet soup, but with renaming things, other things, so that parents are even more confused about whether or not their child is receiving something. If your child's being pulled out, if they're being pulled out of the mainstream classroom for written expression in a small group, or even within the classroom to a different group of kids with a different teacher than the mainstream, if your child is being sent as part of their schedule to a different classroom for their writing from the mainstream, and they're calling it something else, you should ask, is this RTI?
Yeah.
And believe us when we say, once they start to sense, and I don't mean to sound negative about school districts in any way. Julie and I are big believers in public education, and we know that most people get into education to work with children because they care about children and they want to do the right thing. But make no mistake, there are competing financial interests that are at play when it comes to intervention for students, and some internal politics, and just the reality of short staffing and all those things that come into play when it comes to these issues. And so once you start making it clear to your school district that you are starting to research and understand the terminology, they will start to give you a little bit more respect. They're going to pay more attention. Sometimes it doesn't go as the way we'd like, but if they know that you ask the question, what is this RTI? They're going to, whoa, what is this? This parent obviously is doing some homework, which is a good thing. We say it all the time. In order to effectively advocate for your child, you're going to have to become at least somewhat familiar with the federal law that governs special education, because it will only help you in the long run.
And I find that many times, because school districts are required to let parents know that their child is in RTI, but they often won't call it that.
Yeah.
So to Jen's point, they might say, well, we're taking him out in the hallway and he's working with one of our specialists. Is that called RTI? Yeah, that you'd be well served to inquire.
Julie and I have both seen students who've been getting this kind of pre-referral intervention without an IEP or 504 plan for years. Yeah.
And it's not designed. And that's a misuse of its original intent.
Yes. Next slide. Okay, so this is right out of the statute. Actually, these are the regulations, which is also federal law. So there's the statute, and then there are the regulations. They're all part of the IDEA and its implementing regulations. So this is what is written under its section 300.309, determining the existence of a specific learning disability. And what Congress has said is that a child has a specific learning disability under the IDEA if the child does not achieve adequately for the child's age or meets state-approved grade level standards or in one or more of the following areas, when provided with learning experiences and instruction appropriate for the child's age or state-approved grade level standards. And right there, number 3 is written expression, okay? And it's our experience, and we assume most of yours, that school districts are much more accustomed to identifying those reading disabilities than they are the written disabilities. And math is also a challenge. I think it's fair to say that reading tends to be the thing that most districts pick up on more quickly than the other kinds of learning disabilities. But it is right there in the statute that written expression, it can form the basis for an identification as having a specific learning disability.
And also know that, as is all over the Dysgraphia Life website, written expression, if somebody has dysgraphia, it may be coexisting with other learning disabilities as well.
That's an excellent point. And please know, and Julie and I have almost seen it all, but something will happen probably today or tomorrow that we'll say, nope, we've not seen it all at an IEP meeting or some similar thing. This is not a list. This is not a list of that you are required to have all of these things in order to be eligible. That's not how this works. If your child meets criteria for one of these things, they're eligible. And please know your state. So the Congress does allow states to choose their own eligibility categories, as long as they also recognize that they must identify under the federal categories. But your state might have something specific to written expression. I don't know of any that do, and I've not researched it. As an example, in Connecticut, we have a specific learning disability category on an IEP, and we have a very specific different category that says specific learning disabilities / dyslexia for those students who have dyslexia. That happened through Decoding Dyslexia's grassroots efforts throughout the country to try to have schools focus more and more on dyslexia, and they've gone to a number of state legislations and been successful in getting laws passed in that regard. And it certainly would be a wonderful movement to see if in the area of dysgraphia there was more focus at the state level, because getting something through Congress is almost impossible. But you can go to your state and say, written expression is being largely ignored by school districts in our state based on the following data, and we think there should be a specific category for written expression. But whether they have it or not, under the federal law, they're required to identify it. Okay, Julie, anything else on that? Or
no?
Good. Okay.
Nope.
You want me to cover this one, or you want to do it, Julie?
Well, I'm not sure we even, yes, I'll go into it.
Okay.
One of the things that is just so critical to know is, the very first step is you refer your child to special education, right? And check with your state, check with your district on what their process is, go by the book, how they want you to refer your child to special education, put it in writing. And then the school district should be obligated to evaluate your child in all the suspected areas of disability. And please refer to Dysgraphia Life when it comes to some of the specific assessments you can be asking for when referring as it relates specifically to dysgraphia. Now, then you're going to come back to an IEP meeting where you're going to be reviewing these evaluations. And it's going to be determined if you're referring your child for the very first time, that your child is either eligible or they're not eligible. And please look into your own state as to what the eligibility criteria is, whether there's a form you fill out in your state, find out from your state or your district what the form is or what the criteria is, so that you're aware of that before so you can go over it with them while you're at the IEP team meeting.
Julie and I say, I'm sorry, Julie, I didn't mean to interrupt you.
That's okay.
Julie and I say frequently that the right to an independent educational evaluation and public expense is probably the most important procedural safeguard under the statute. It is your right to have someone who doesn't have a vested interest in the outcome of the recommendations and diagnoses evaluate your child. It's important.
Right. So thank you, Jen. And, if you're at the very first eligibility IEPT meeting, sorry, that's what we call them in Connecticut. That's a slip of the tongue. When you're in this meeting, you're going to determine whether or not your child is eligible or not. Either way, you have a fundamental right to be able to disagree with the district's evaluations once they have conducted them. You do not have to explain why you disagree with them. And that's because the feds, when they put these laws together, realize that you're not a psychologist, you're not a speech and language pathologist, most likely. You're not an expert. And you then have a right to what's called an IEE, or an independent educational evaluation. And that is a fundamental right that we want you to know about. And again, some states, you can ask for an IEE at an IEPT meeting, and other states might say, well, that's not an IEP decision. You have to write a separate letter to the director of special education around that. Again, ask your specific district how that rolls out in your own state. Jen, what else do you want to say about an IEE?
Just that the law around it is very, very complicated. Not to be too obvious about plugging our book, but we've been told by a lot of people that the section of our book that covers IEEs is extremely helpful to them because it's very complex. And that book is Your Special Education Rights, What Your School District Isn't Telling You. And you can find it on Amazon if you want to do a deeper dive into IEEs. And
I have one more thing to say about an IEE. By definition, an IEE is that it's free and clear of any involvement from the school district. And oftentimes the school district will give you a list of evaluators. And what I always like to say when they give a list is to say, well, thank you very much. We'll consider those. But please understand you don't have to choose from that list. You are free to choose whomever you want, but it will often need to meet the criteria that the district has laid out for an IEE. And again, that might be different in every state.
Yeah. Okay, next slide.
Oh.
Are we at the end of our slides?
Well, apparently.
We are at the end of the slides.
Beautiful.
Well, this is where, for everybody, we wanted to get through the slides as much as possible because we'd love to ask questions, answer questions. And we think that's where, we can be a little bit more helpful in talking about specifics.
And we definitely have some questions coming in, and for everyone, continue to put them in the Q&A box. I'm going to kind of group them and ask them. There was one specifically about the IE evaluators that you were just talking about, that they're saying that they're running into some confusing contracts, that it gives the impression that the evaluators actually work for the district and have to answer to the district. Is there any way to get around that, or how does that whole process work?
Great question. That's a great question. So what happens is once an IE is approved, the district usually does enter into a contract with the evaluator, and they should, because they specify how much they're going to pay them and when they expect it to be done, and that the timelines that are required under the law will be met by the evaluator to complete it in a timely fashion. All of that makes sense. We very often see school districts try to stick into a contract something that would actually be a violation of the parent's right to an independent evaluation. Those are things like you assure the school district that you are going to give us a draft of the IEE before we send it to the parent, and you will not send the parent a draft in advance. That's not okay. And please know there are decisions on this from the courts. There is guidance from the federal government on these issues. There are tons of letters to so-and-so, which are the U.S. Department of Education saying, you've asked me this question, is it okay for us to put a cap on the independent evaluation as a school district? Here's our answer. As long as it doesn't fly in the face of a parent's right to a truly independent evaluation. And that's the key. Putting anything into these contracts that essentially says that the evaluator agrees by signing the contract that the district gets to decide what is in the evaluation flies in the face of the parent's right to an independent evaluation. Now, how do you prove that? Okay. First of all, we do suggest to parents that they ask for a copy of the contract with the independent evaluator if it's been granted. And if the district says no, you have a right to that contract under two different statutes. One is under FERPA, which is the law that governs Educational records. So as a parent, you have a right to access copies of your child's educational records, and that would become an educational record, that contract, if it specifies an individual child. And if it's a contract for many children, so some of which would raise a red flag for me if this district has a contract with one person for numerous children or for a number of evaluations per year. How independent is that person actually? Because you can be technically independent under the law, meaning you're not employed by the district, but still biased. Okay. If most of your business is coming from school districts, that raises a big red flag as to whether this is going to be the kind of independent evaluation that you want. But you have a right to that if it's a contract with the district, and for several people under a different statute, which is the Freedom of Information Act. So if it's just generally a contract between X school district and Y evaluator for all children who have autism or who have a written expression disability, that's going to be available to you under both of those statutes. So you have a right to ask for it. And we argue that you should. We don't think you should do it in a acrimonious way, but simply thank you so much for approving the independent evaluation with Dr. So-and-so. I would appreciate a copy of the contract that the district is entering into with that person. And if there are things in it that trouble you, that feel in your gut, like this is basically the school district trying to tell this person what to do, and that this person is now, working for the district just because they're writing the check for the independent evaluation, I would raise those concerns out of the gate, because one of the worst things that can happen for a family who's trying to get their child services and the school's resisting it is to get an independent evaluation that doesn't support your case, because you have almost, even if you go out and get a different evaluation on at your own expense with somebody else, it's going to be very, very hard to overcome that the independent evaluator ruled that the district's program is appropriate or that the child doesn't have a disability. Julie, you want to add to that?
Yeah, Jen, well, I felt like I wanted to have you take a breath.
Everyone feels that way when they're around me. You know this after all these years.
So two things I want to say. Number one, I'll tell a story really quickly about what Jen was talking about, the fact that the evaluation should come to the parents at the same time that it comes to the district. I worked with a family they weren't getting the evaluation, and we knew that the school district had it. And so we asked for the school district's evaluation and we got it. But then the parent also asked for the evaluation from the actual evaluator, and she did a word-by-word comparison, and the district had asked the evaluator to change a word from "this child would benefit from XYZ" to "this child could benefit." And in fact, that completely violated the very definition of an IEE that should be free and clear of any involvement from the school district. And the only other thing I was going to say is FERPA stands for the Family Education Rights and Privacy Act that Jen referred to.
Yes.
That's great. It's fantastic information. We have lots of questions coming in. I'm looking, there's 3 or 4 that are kind of the same general topic with different specifics, which are, I'm coming in and my school is telling me that my child is not going to officially be eligible because of either they're so young they'll catch up. There's one where it's, they're really smart and so they're not far enough beyond grade level, which we do see those issues with choice exceptional students. So I would love to have you comment on that. They won't recognize outside evaluations from a private outside, neuropsychologist, or they accepted the evaluation, but they say their bar is different than the evaluation. So kind of 4 or 5 different situations where the school is saying, no, we don't need to do this, but the parent and or outside private evaluation say there's probably an issue here. What can be done? What do you recommend? Where should these families kind of start next?
Good question. All right, let me start with the outside evaluation not being considered by the IEP team. By law, the IEP team is required to consider any information that the parent brings to the team, and that includes outside evaluations. Now, the word consider is a pretty nebulous term. It's not, doesn't have a lot of teeth there. If you read it, you probably have been deemed to have considered it. Okay.
Yeah.
Which is why that IE is so important, because it's much more likely that the school team will consider it thoroughly, an evaluation that they paid for, and that because they know that even if they did it begrudgingly because the parent, was ready to exercise their due process rights, et cetera, they know that if it gets to a hearing officer or to a court, if they agreed to provide this evaluation and they paid for it, they're going to be deemed to be somewhat responsible for following recommendations, even if though they're not required to follow all of those recommendations. And we hear frequently these kinds of nebulous for intelligent students who are still very far from where they should be based on their cognitive ability, but not terribly below grade level. We hear this all the time, that this child is really, they're only a little bit behind. We're not concerned about it. It's just the reality. You're just going to have to keep at them. Okay. This is, as I tell my clients, this is not a sprint. This is an endurance test. Okay. And so you need to just document it. You need to be putting it on the record. You need to, unfortunately be, and we don't advise people to become so difficult that they are perceived as being uncooperative with the school district, because you are supposed to cooperate with them. But you need to be documenting your concerns, because very frequently families talk to teachers, they have a good relationship with the team, they have a lot of conversations in the hallways or at parent teaching conferences or on the phone, and they don't document it. And later we don't have a record of it. So we ask parents and we train parents, you should be putting it in writing, sending them an email. I just want to raise again, keeping copies in the area of dysgraphia of work samples that come home. Because, very often when a school district is trying to deny that there is an issue or downplay it, what they'll do is they'll come to that IEP meeting with a finished product, a written document of the child's that took 2 or 3 rewrites with an adult, or sometimes even a special educator, but at minimum a paraprofessional helping them to redo it. And then they come to the meeting and say, look, this looks great. He's doing well. What did it take to get there? Because when he writes at home, and be prepared to bring in Christmas cards or whatever it is, that the thank you note that you made your child write to their aunt, and it took them 6 hours and you can't read it. I mean, that's the kind of thing you have to unfortunately do to document your case. Julie?
Right. Yeah, I also think that this is where I would advise that you get your district's curriculum, your not only the curriculum, what is the curriculum for the grade? What is the scope and sequence of the grade? Compare that to the federal, the Common Core standards, because the devil is in the details.
Yeah.
And go back to the grades even before the grade your child is in, and look at all of the benchmarks they're supposed to meet for handwriting, sentence length, capitalization, all of those things, and highlight all the things that they still can't do, or that they're challenged in. And I always say we can't come to the IEP table with just an emotional plea. We have to come to the IEP table with the evidence, with the data. And so you bring that data to the table. So find out what the standards actually are and what skills they're supposed to have by their grade level, and then document what that actually looks like. And then also, this is where you need to understand what the eligibility criteria is. And there's the federal eligibility criteria that we shared with you, right? And the statute. But understand that most states and or districts can have their own eligibility criteria, which should not undermine or lower the ceiling of what the federal standards are for being eligible. And so the devil is in the details. Jen and I have a chapter in our book called Urban Legends, and school districts have cultures, and there are things that they're told to say that get said for years and years and years, and people say them and they really don't even know what the law is behind them, whether or not that's reality or not. So oftentimes parents are told, whether it's wittingly or unwittingly from people who work in these districts, things that simply aren't true. And so this is where you need to actually know what the eligibility criteria is and go to the curriculum to find out what they're actually supposed to be what they're actually supposed to know and perform.
And also ask those follow-up questions. Many, especially in early elementary school, when teachers, are really wanting to make sure that the children are successful and they're really working with them, especially really likable little kids, right? Very frequently they're given informal modifications. And so, if it may not be in a 504 plan or an IEP, but the teacher's always allowing this child to rewrite their written assignments. They're always allowing them to be in a corner with the classroom aide doing their written assignments. These are the follow-up questions you need to ask, because parents, you need to trust your gut instincts. If you're not seeing it at home, and COVID has opened up this whole wide world of parents who actually saw what their children were doing in real time. We have a lot of families who suspected, and then now they know, right? Because they saw it. Ask those follow-up questions. Did he do this independently? Was she alone? Because at home, when we ask her to write anything, it's tears, it's fighting, it's this, and you just have to get these things on the record.
And one more thing, sadly, and again, a reminder, we are 4 school districts, but we also are called in when things don't go well. And we have lots of friends who are special education teachers or regular education teachers. And we know, unfortunately, that some, not all, districts can actually, have edicts, if you will, that, we're done with referring kids this year, so, or, we can't refer any more kids, the barn is full. So that's a reality. So they say things like that because they want to push it off to another year, maybe.
Well, and I saw it in the chat and in the Q&A, some questions that are hitting at those urban legends we're talking about. We don't do that in middle school. We don't do that here is always a red flag.
Oh, yeah.
Or it's our policy that, and when they say it's our policy, your response should be, can I please have a copy of that policy?
Yeah,
Usually
the
it isn't
written
a policy. It's usually a practice. If it's a policy, somebody should have voted on it, and it's got to be in writing. And so you need to have a copy of it. It's usually, in fact, just a practice. And it's usually, if they're saying we don't do that here, it's usually a violation of something.
Yeah. And the other thing,
I'm curious when and this isn't a specific question, but I think related, when do you advise that parents bring in an external advocate to their meetings? Because you are legally, I'm hoping most people here know you are legally allowed to do that. Most parents don't start with that. They start by going in themselves. What are those red flags, or what are those points where you guys would advise, okay, you should really bring in an advocate on your behalf with you to these meetings?
Julie, why don't you take that one, and I'll just jump in after.
Yeah, I would say really the very second that you find that you're not being effective. Jen and I work with parents who are the smartest of smartest people on the planet, and attorneys and doctors and all sorts of really smart people. So it has nothing to do with the fact that you might be a very capable human being. But if you don't understand these laws, it's, what you say and what you don't say can hurt you. And oftentimes when you bring in an advocate, and you should always start with an advocate. You really don't come in with an attorney as your first step, because an attorney is really designed for when you're actually in a dispute with your school district. So start with an advocate because you don't want to be in a dispute with your school district, right? So oftentimes by just starting with an advocate, it's letting the school district know, oh, they've just elevated this and they're coming in at a different level now. And now the playing field is a little bit different,
Yeah.
So I would say don't wait too long.
How do you find an advocate?
We'll get to that. Go ahead,
Yeah.
Jen.
So let me just say this. School districts are given training. The administration is given training, both in their education, but then frequently through their experience over years in some situations of going to due process hearings with their attorney, having an attorney at the other end of the phone who represents the school district. Some directors in some districts have been doing it for years and could probably teach a course on special education law. And you haven't, okay? It is an uneven playing field out of the gate. They understand the terminology. They have your child all day, and you only get some of the information about what happens during that day home. It is inherently an uneven playing field, and Julie's spot on. If you can, there are rare circumstances where you really want to start with an attorney, and they should be pretty extraordinary, like your child's up for some significant disciplinary action, like an expulsion, and you've been worried for years and you think they're acting out because of an unremediated learning disability, like, hospitalizations, things like that. Starting with a lawyer is not smart, but if you keep at it and they won't identify your child or they won't provide them services, and you've brought in an advocate, obviously then many families get frustrated enough when they bring in an attorney, but it shouldn't be your go-to. Advocates, unlike attorneys, though, are not regulated in any way. There is no certification, although COPAA offers SEAT training, special education advocacy training, which is an excellent program. And we certainly suggest that COPAA is a good place to start. So it's COPAA.org to both find an advocate, and also the membership for parents is excellent. The conference is amazing. This year we'll be in San Francisco in March, and you can have access to the listservs where you talk to other families and advocates and get a sense of what your rights are. But I would certainly, if you're going to find an advocate, just make sure you check, because there are some people who are not really well trained and they're just holding themselves out as advocates. There are people who are parents who, are reliving some issues with their own school district. I mean, there are some, just like there are attorneys out there who have no clue what they're doing in this field, but do it anyway because a client that they have asked them to handle it. You want to make sure you're finding someone who's experienced, and if possible, experienced in dealing with your school district.
And I think one of the best ways for parents today, other than going to COPAA, and because the members of COPAA are listed by state where you could find advocates and attorneys. But the other way is social media. There's lots of chat groups out there, and who better to give feedback on advocates than parents? And my understanding is on these chat groups, they just tell it like it is, and they'll, and that's a really good way to find an advocate as well.
That's a great idea. We started a professionals database. It's making me think that maybe we should add an advocate category too for people to go find advocates. So possibly a future state. For a couple people who asked specific questions about accommodations and IEP goals, I will say that Dysgraphia Life is putting out an ebook that will be out in January that talks much more specifically about what the accommodations could be at different grade levels, as well as examples of different IEP goals at different times during the course. So I think we're going to save Julie and Jennifer's time to talk more about the legal aspects and not the specific accommodations, but we do have some resources on the website already, and we'll be addressing that even more thoroughly when the book comes out in January. I did want to touch on 504s versus IEPs again, because a number of people I've talked to come up against, particularly with dysgraphia, we're not going to give you an IEP. What we're going to do is give you a 504 with technology accommodations. And even in my own journey, I've heard, even if you had an IEP, oh, well, now they're progressing far enough, we want to drop you down to a 504 because you don't need those goals anymore. What is your take on the two different mechanisms, and how do you potentially ensure you can get the sort of IEP level services different from just the accommodations?
If I could just start with this, Jen, that I just want to, as a primer, right? You really need to understand the difference between accommodations and modifications, because oftentimes they're bantied about and people get confused about what they are. An accommodation is the only thing you can have under a 504 plan. You cannot have modifications. So if your child has an IEP, you should be figuring out what are their accommodations and what are their modifications, because that a modification is when you literally are changing the expectation, right, that the child has to deliver, or you're changing the presentation of the material, pretty drastically. An accommodation is when you are just making sure they don't get discriminated against. You can sit over here in this room because you're easily distracted, but we're not changing anything about the actual material that's being presented to them, right? So I just wanted to start by saying, know your accommodations versus your modifications. Go ahead, Jen.
Great suggestion. So the way you can conceptualize these two statutes, because I think it's helpful for you as a parent to say, do I think I fall in this category or that category? Does my child? So the IDEA is a services act. Under the IDEA, a child who has an IEP also is entitled to accommodations and modifications, okay? Section 504 is an accommodations act, okay? It is an act that doesn't provide specialized instruction. You don't teach the child differently. The child is given accommodations to access their education because of their disability. That's very different. Okay, so a good way to look at it is a student who has a peanut allergy would get a 504 plan because they need to have a nut-free cafeteria, and they might need certain things to be set up differently so that they're not exposed to the allergen. They are not going to be taught any differently, right? Okay, the harder cases are cases like children who have dysgraphia, attention deficit, et cetera, where the school district's saying, well, we can handle this just by providing those accommodations. It's hard to imagine intervention for dysgraphia without services, isn't it? It's hard for me to imagine. I'm not an educator, but it's hard for me to imagine that just giving a student extra time to complete an assignment is going to actually provide intervention. Because how is the child learning to write? How is the child learning to write differently? Technology is amazing. And for many children with dysgraphia, certainly as they get older, and as we look to middle and high school, that assistive technology piece can be the bridge to having school and your experience there dramatically improved because of technology. And the IDEA requires that at least every time the IEP is revised, the team considers assistive technology, which for children with dysgraphia is very important. And we certainly encourage families and districts to use the technology that exists to make these experiences easier for students, because it is, it can be socially isolating to have certain accommodations in place in a regular ed classroom, whereas with technology, so many kids use it who don't have disabilities, and so it just becomes part of the seamless nature of everyone has a device in front of them, and it just may be that this child's device has more software on it and nobody really notices. So it's really great to use it, but it should supplement services, not supplant them. Okay. And so we just suggest to families that if you don't think your school district understands dysgraphia, which many don't, or you don't think they're really recognizing it for your child, exercise your right to an independent evaluation. Make sure you get somebody who does understand dysgraphia to do the evaluation and ask around, because they may be an expert in a different kind of disability, and present it to your team.
I would also say that by the time you get to assistive technology, as Jen said, is a wonderful thing. You could still be using assistive technology, but the point is to ask the question, what lagging skills is this assistive technology masking? Okay, what can my child not do? Because you could still have the IEP address whatever the fundamental lagging skill is. So for example, if it's capitalization, does it mean you're giving up on, well, he's just never going to capitalize again as long as he lives, okay? Or do you still get to work on that as an IEP goal, but at the same time, in reality, they're learning to use capitalization that has an auto-correct, feature to it. So assistive technology, just because you use it, doesn't mean you abandon the right
to write,
the ability to still have a skill.
Yeah. Well, and as Julie referenced earlier, use that Common Core, use the standards that exist in your district for students who do not have disabilities, because they cannot have they cannot hold your child to a different standard. And they cannot say to you in an IEP team meeting, we don't care about whether or not he learns to capitalize. If the Common Core for that grade specifically says that by the end of 4th grade, children are going to be able to do X, Y, and Z in this district, to have your child be held to a different standard would be a Section 504 violation under the fact that they're offering a service or benefit to students who do not have disabilities that they're not offering to students who do.
That's great. I'm scrolling through. We have lots of questions. About 5 minutes left. I guess I'm kind of want to go to the two of you with the last 5 minutes of sort of what do you think the most important takeaways are if you are starting to approach your school district or you're struggling with your school district. How do you make this happen for your student? What are your best tips?
Well, it's interesting. I've got many, but I just want to start with that. If you're having trouble getting your child identified, right? Don't come in with just the emotional argument. Come in with the samples. Come in with the data. Here it is. Here's what it looks like. Here's what it observably looks like. And because, like Jen said before, school districts and say, well, here's what it looks like. And it was something that, was worked on over 2 weeks and it's convincing, like, well, I guess everything's fine then. But I'm going to start with that, but Jen, go on, because I had something else to say, but I need to formulate it.
That's okay. Sure. So the number one thing I always say is trust your instincts. As a parent, it's very common that your concerns and your that the feeling you have in your gut that something's not right with your child is accurate, and schools are very skilled at, and it sort of plays into a psychological need we all have to believe our children are doing well, that schools will downplay it frequently, especially if they don't have a lot of expertise in the area of dysgraphia, and they will tell you everything's fine, and they will show you examples of why everything's fine, and they may be right. But the reason that you want that independent educational evaluation as soon into your child's education as possible is even the best evaluators who work for school districts are employed by the district that's obligated to provide the service. And that means that whether they're the most talented evaluator in the world and they have the biggest heart, at the end of the day, they have to make a recommendation that their boss has to pay for. And that is an inherent bias. And so the number one thing I say to every parent, my friends who have children who call me, you get into this field, and by the time you're all having children, everyone has questions, right? And I say to them, more than an advocate, more than an attorney, you need a good independent evaluation to tell you what your child's disability is from someone who doesn't have a vested interest in the outcome of the recommendation. So I feel that between learning your rights, which Julie and I are passionate about making sure we bring to the mainstream, that's why we do this kind of thing frequently, this kind of webinar. We are passionate about it. Know your rights and get a good independent evaluation.
And are those independent evaluations allowed to suggest goals? That was one question that came up. Or is that just the evaluation for the need for?
Of course, they're allowed to suggest goals. Yes.
Okay.
And if you're being told no, they're not allowed to suggest goals, I would argue that that there's no legal basis for such a position.
When you actually look up like an evaluation and what the criteria should be, as I like to say, an evaluation is worth the paper it's written on if it doesn't have prescriptive recommendations. And as anybody who's doing an assessment, to be ethical, you can't just say, well, you've got a broken arm, right? You need to now say, what do you need to do about this broken arm? Okay. It's not just to diagnose something, it's also to make prescriptive recommendations about what to do about it. I always like to tell parents, ask of your district's evaluations and of your independent evaluations to have diagnostic and programming questions. Diagnostic, what is the disability? What is the challenge? Programming, what are the specific interventions that need to be in place for this child to have an appropriate program, etc. But what I was going to say as my takeaway is, look, this is all about lagging skills and identifying the lagging skills. And I just had an IEP this morning where my client was unfortunately determined not to be eligible, which we disagree with. And so I said to the parent, okay, they're not eligible, but you know what? We'd like to have several meetings with the regular ed teacher. I want to know, what strategies are you teaching my son? What can you teach me to help support the homework? I want to be more involved in understanding what the prompts are, what the lessons are, what his work looks like coming home. Because the more detached you are from what actually is going on, the easier it is, and I don't mean this in the wrong way, that the wool is pulled over your eye. And maybe the wool isn't pulled over your eyes intentionally, right? But teachers are so the hardest working people on the planet, right? They're tasked with so much responsibility. So many edicts come down to them from administration. They're under a lot of stress and pressure. And they can't be everything to everyone all the time. But if you become more aware of what's actually going on in school and how they're teaching your child, the less likely it is, or the more likely it is, that you might find some cracks.
That's great advice. And so I think the takeaway from all of this is to be as informed as possible, and to bring in advocates where you need help, and can bring in that expertise to be even more informed than you are. We really, really appreciate your time, to both of you today. This was fabulous. To those watching, we were recording this session. We'll be sending it out in 7 days. It'll be posted on the Dysgraphia Life website. We'll send the link, and yes, you can share. That was already asked. Thank you so much to Jennifer and Julie. We will also include links to their podcast and their book and everything on that page when we have it up. We greatly appreciate your time today. Happy Thanksgiving in advance to everyone watching. And thank you. We try to do this quarterly, so we will be back in the new year with another webinar. So
thanks for having us, Jennifer.
Thank you,
appreciate
Jennifer.
it.
Take care.
Bye.